So today we have a fascinating book talk by Professor Elena Alviar Garcias, who recently published her latest book, Legal Experiments for Development in Latin America. It is a fascinating work that spans a number of areas, from transitional justice to economic law, investment, property rights, gender, and a number of other topics that I'm not going to be able to summarize here, but we will hear from her. And then Professor Mattias Gilos will provide a discussion or an introduction or comments on some of these topics, and following Professor Alviar's presentation and Professor Gilos' comments, we will have some time for Q&A. So before I give the floor to Professor Elena Alviar, let me just say that she's a professor at Sciences Po Law in Paris, in France. She's an expert in law and development, property law, social and economic rights, feminism, and transitional justice. She has written extensively in all these areas. Her books, chapters, articles are just too many to list here, but I suggest and I recommend all of them. She's a prolific scholar who comes from Colombia, where she obtained her law degree at the Universidad de los Andes, where she was a professor and served as dean. She also holds an SJD from Harvard Law School, and she has been a visiting professor in a number of universities in Latin America, Europe, and the United States. Professor Alviar is also the co-founder of De Justicia, one of the leading human rights NGOs in the Global South, based in Colombia. And she's an academic member of the Institute for Global Law and Policy, IGLP, at Harvard Law School. Professor Mattias Gilos teaches at the Diego Portales University Law School in Santiago, Chile, where he teaches courses in administrative law. His main research interest concerns the intersection of property rights with governmental regulation, where he has also written an extensive body of literature on all of these topics. He holds an LL law degree from Diego Portales University, an LLM from Columbia University, and an SJD from the University of Arizona. So without further ado, I'll give the floor to Professor Alviar, and then I'll give the floor to Professor Gilos. Elena, thank you for being here.
Thank you very much. And first of all, I wanted to thank Jorge, Katie, who's there as well, the ACIL, the Latin American Interest Group in ACIL, and also the Rutgers Center for Transnational Law for organizing the event. I'm really, really thrilled. This is a book that I started thinking about many years ago, but I wrote during the pandemic, and I haven't had a chance. So this is one of the first opportunities I have to talk about the book. So really my deepest thanks to all of you. I'm going to share the screen. And I don't know if you can see the presentation. Can you see it? Okay, so I think I have to do something here, which is this, and that way you can see it a bit better. So what I'm going to do is that I am going to, first I'm going to give a short introduction to the book. What are the book's objectives? Then I'm going to present a summary of the chapters. Before the summary of the chapters, I'm going to present a few overarching framing topics, then a short summary of the chapters, and then some conclusions and future projects. I don't know why this, okay, here. So the book synthesizes 10 years of my thinking about these topics and of teaching a course on Latin American law and institutions. It was triggered by an experience I had more than 10 years ago, in a Law and Society conference in Berlin. It was announced that there was going to be a conference on progressive law in Latin America. And I went there, and it was a panel, of course, only men, and all of them accounted for constitutional reform after constitutional reform in Latin America. And I strongly opposed that view of progressive law. I thought that constitutional law is part of the story, but is not the whole story. And it doesn't definitely say why those, progressive constitutions actually have not hit the ground in a region that is highly characterized by inequality. So I started thinking about the topics of this book, and I also started writing about things that I mentioned in the book. And so the objectives are to discuss the interaction between law and economic development as a tool, law as a tool, law as an obstacle, or law as an accomplice in exploitation, for example, but also to analyze how diverse economic development models have incorporated law in 4 big topics: to regulate foreign investment, so that's the first chapter; to provide access to property; to incorporate women in the development goals; and to design public social policy. I also want to propose a broader view of law, and I will speak a bit more about that throughout the presentation. Now, I start out with this image of work by Muna Hatoum, which is called Light Sentence, but I actually like it very much because I think that part of what I'm trying to do is to radiate light into diverse ways of thinking about the topic, the big topic of law and development. I'm going to spend a little bit of time talking about like overarching topics that are characteristic of the whole book. So I concentrate on 3 distinct economic development models. First is a liberal interventionist model with an emphasis on the social, a dependency-inspired model, and a neoliberal one. And I'll talk a bit about what I understand by each one. The idea, of course, in the book, it's a very short book, I'm very proud of it, but it's very short, is that these are archetypes and they don't represent a perfect model. So no single country represents either dependency theory or pure neoliberalism. Actually, that's one of the main objectives of the book. And one of the reasons for me, it's very important to structure these models is because as a professor, when I present these ideas in class, I want students to understand where they situate themselves politically and to make a decision of, which is the model they embrace, what are the ideas that they want to try to set forth, etc. In a way, politicize the classroom. Now, by liberal interventionism, I'm referring to the combination of policies which defined import substitution industrialization. This model, as most of you know, requires strong state intervention in leading and designing the economy. So it is about, state intervention in the economy, for example, to protect local industry, along with a range of state policies to protect workers, such as the minimum wage, tying benefits to a salary, as well as subsidies over public services. The central idea is to redistribute resources, not only for reasons related to the search for equality, but also to grant citizens the power to buy goods that are produced locally in the market. Now, many countries in Latin America during the 1960s and 70s adopted this model, but still today, and even in the wake of the pandemic, it's a model that is being revived both in the global South, and I would argue that in the global North as well. And so it's as relevant today as it was in the 1960s and 70s, and we can talk a bit about that during the Q&A. In the dependentista model, I understand, so that's the second one, I understand it as a critique of the term, well, it is many things, but for this presentation, it is a critique of the term underdevelopment. For dependentistas, underdevelopment is not a state previous to economic development, but a consequence of colonialism and exploitation exercised by countries in the North. This explains why countries in the global South produce mostly agricultural goods or mineral products, with all the consequences that this has, and I'll talk a bit about that in the chapter on social policy. The chapter discusses the different chapters discuss the dependentista model, the classical dependentista model, which is Cuba, but I also mentioned Bolivia, for example, as an example of a country that incorporates indigenous heritage to the definition of development, buen vivir, and the relationship between men and women. Now, by neoliberalism, I mean the economic development model, which is both a critique of the strong state presence that is typical of neoclassical interventionism and a dependency theory, but also a critique of the ideas of what is growth and how it should be distributed, or who should distribute growth. For neoliberalism, the state should be slim, which is why austerity and privatization are so crucial. And again, we will go back to these topics later, and should be replaced by the market. So the market is the best distributor of resources. In this sense, countries should concentrate on the production of goods in which they have a comparative advantage. In other words, foreground agriculture and mining, or the service sector, for example, in tourism. Many countries in the region have embraced neoliberalism, actually most of them at some period, but the book discusses Peru, Colombia, and Chile at certain parts. Neoliberalism in the book is also understood, and this is the part that I find most interesting, as a way of governance. By providing social services through needs-based tests, so not at a universal scale, so social policy for workers or for the unemployed, no. In neoliberalism, social policies are granted after a means-based test, and, for example, measuring state results through indexes, as if government was a business. Countries that have been very representative in this style of governance would be, again, Colombia and Peru, but I think it's prevalent in many places. Now, in the book, I have a very particular view of law. Well, as my initial anecdote shows, I oppose the centrality that constitutional law has played in the descriptions of the region. Starting from the Mexican Revolution or the Colombian Constitution, and even discussions now, and I hope my two Chilean colleagues forgive me, but even discussions now about the centrality of the Chilean Constitution, which is a beautiful process. I'm not critiquing it, but I think that there's much more work to do along with the constitutional reform on the sides. Without wanting to deny its relevance, as I said, I think constitutional law interacts with other legal regimes that limit or strengthen its transformative potential. And this is one of the big goals of the book. I disagree with those who think that by transforming laws, you transform society. But I also disagree with those who think that laws are always structurally biased because they are determined by the owners of the means of production. My position is different. It proposes that it is precisely in the interaction between constitutional law and private law, for example, or constitutional law and labor law, that progressive rules flourish or flounder. I am also very interested in the way in which law distributes power, money, or access to the state, among others. And of course, we can talk a bit about this during the Q&A. Now, the last overarching topic is that each chapter begins with a brief reference to a work of fiction. I do this in order to illustrate the multiple dimensions that each topic has: the invisible and emotional costs of land dispossession or power concentration by multinational companies. But my aim is also to foreground the ambivalence that women have toward motherhood, one of the fundamental issues that frames women's access to work, and the similarities between the facing of the pandemic in the times of 100 years of solitude. So now to the chapter summaries. And I included, this is a painting by Guillermo Wiedemann, who's a Colombian painter. And so what I hope to transmit through this image is that on the one hand, you're trying to regulate foreign investment through a constitution. So those would be like the red squares in the center, but there's always something that is going to bleed into other colors. So, excuse me. The chapter begins with a reference from Rachel Kushner's novel, Telex from Cuba, which deals with the power exercised by US businessmen before the Cuban Revolution. It explores how foreign investment has been drafted into constitutions across the region as a way to exclude the regulation of foreign investment from a democratic debate. In the case of neoliberalism, the form it takes is a promotion of foreign investment, the protection of private property as absolute, including austerity and free market as fundamental aspects of a societal organization. In the chapter, I talk a bit about this. This is the case of Peru, which, well, maybe it's going to change, but that was the case when I was writing the book. In the liberal interventionist model, also called Estado Social de Derecho, the Constitution states that free market will be protected, but that when necessary, the common good will prevail. So as you see, it's not as extreme as the first example. It's a middle ground. Foreign investment is allowed, but a degree of supervision by the state and their property has a social function. For a dependentista constitution, foreign investment is prohibited in most cases, and the property over essential goods belongs to the nation. The chapter ultimately argues that for good and for ill, concentrating your political energy in constitutional reform hardly ever gives the expected results. There are always restrictions in terms of the interaction with diverse legal regimes. For example, with labor rights in neoliberal systems, judicial interpretation when constitutions have social and economic rights, which happens in el Estado Social de Derecho, but also global market conditions or private property protection in regimes such as the Cuban, dependentista regimes such as the Cuban or Bolivian one. So this is access to property. I'm sorry, the image is not very nice, but it's a mural by Diego Rivera, and it's about agrarian reform adjudication. The chapter begins with a quote from Pedro Páramo, one of the most important narrations regarding big landowners in the region. Rulfo presents in a poetic and precise way what are the emotional, economic, political, and social consequences of property accumulation. The text lays out the evolution of the term, the social function of property, which has served in some countries as the middle point between socialism and capitalism, and this in turn was used to theoretically support agrarian reform across the region. It also discusses what was the role of the social function of property in relation to import substitution industrialization, which I referred to initially. It explores how the social function of property also served more radical projects, such as land redistribution in Cuba and Venezuela. As a counterpoint, the chapter analyzes Hernando de Soto's proposal of formalizing individual property as a way to empower those who don't have titles over rural or urban housing, with the objective of strengthening the free movement of property in the market. And this is, the strengthening of the market, and the market as the best distributor of resources is completely related to my description of neoliberalism that I did previously. The chapter ends with a discussion of the multiple limitations that the social function has had in relation to its distributive impulse and economic development models. For example, the social function of property is incompatible with neoliberal economic development models that promote land accumulation for agribusiness, and I described that a bit in the chapter. The following chapter is a chapter on gender, and I chose this beautiful picture by Dorothea Lange of a mother with with her sons, or son and daughter. The chapter starts with a reference to Elena Ferrante and the way she depicts the limitations that motherhood imposes over women at a personal level that are transferred to the labor environment. Then it describes the different ways in which women have been incorporated into economic development models as an issue of equality, as a problem of the separation between productive and reproductive work, or as a critique of economic development models based solely on growth, and the call of celebrating women as better protectors of the environment. So very typical in Ecuador and also in Bolivia. It explores examples from liberal, socialist, and cultural feminists, and it ends arguing that the strongest feminism in the region has been liberal feminism, and I point out which are the limitations that this provides. The last chapter is a chapter on social policy. The chapter starts with a reference to the insomnia sickness that overtakes Macondo in 100 Years of Solitude, in order to discuss how the tools at hand to counteract the pandemic resonate with the same ones that we had about a year and a half ago. Then it argues that the way that many countries in Latin America have structured their social policy in times of neoliberalism through conditional cash transfers, which are needs-based, as I explained at the beginning, and health privatization, along with the return of the free market and comparative advantage in the form of exporting agricultural products or minerals, as I also explained, or tourism, left the region in the worst possible position to face the pandemic. So the region was structurally hand-tied because of the consequence of so many years of means-based social policy, and also combined with health privatization and the export-led growth. The text analyzes different models of social policy and explores how they are related to the tools that governments could use to face the pandemic. The book ends with a few conclusions, and I brought this picture of a Colombian photographer whose name is Leo Mattias, and the picture is called Pavo Real, which is, I don't know the word in English, but it will come to me. Ultimately,
Peacock.
Peacock, thank you. Ultimately, my aim in the book is to move away from a view of law that is separated by disciplines, and instead to look at the diverse forms in which they interact with each other, along with ideas about economic development, culture, and global capitalism. I want to propose that there is a permanent interaction between, for example, what a constitution says and what contracts include, what corporations are allowed or not allowed to do, the content of family law, labor law, and criminal law, among others. I wanted to end with a couple of future projects that are related to the experience of writing this book, which is now I'm engaged on trying to write a book about law and development, but from a start that has as a starting point products. So products that have been very important for the region, like coffee, sugar, banana, flowers, and palm oil. And I would also, because this is also so important for the book generally, continue to explore the relationship between the arts and the law. So thank you very much, and I'm going to stop sharing my screen.
Thank you very much, Elena, for this presentation. I'll give the floor right away to Mattias Gilos, and then we'll have some time for Q&A. Mattias, the floor is yours. You're muted.
I would like to thank, first of all, the Rutgers University Law School Center for Transnational Law and Professor Jorge Contese for this invitation. Since I'm not a native speaker, and in order to use the words that better communicate my impressions on the book, I will read my presentation. Sorry for that. In the next few minutes, I will provide just a few general remarks on the book, and then deal with its treatment of the subject between the relationship between law and development. Then, after some concluding remarks, I will formulate some questions that the book's reading provoked me. Let me start by offering some general remarks about the book's objects, methodology, and contents. I've been lucky enough to know Elena for a while, and it's great to see on paper many of the amazing ideas I heard her talking about over the years concerning subjects such as property, gender, the role of law, and the connection between law and literature. Using the perspective of law and development, the book engages the fascinating topic of the relationship between law and change, describing the legal experiments undertaken in Latin America to reach goals of modernization and economic transformation. As to the book's methodology, the analysis of the topics that the book deals with, as Elena underscored, is not comprehensive, but it's rather intended to unveil the theoretical archetypes that represent a specific ideological sensibility towards them. For instance, concerning economic development in the region, the three archetypes are neoliberalism, the social approach, and dependency theory. Additionally, to illustrate how the legal experiments that the book analyzes shape and have a profound impact on the lives of people subject to them, Helena starts its chapter with a reference to literature. Literature is a suitable device for doing this because, just like law, as Elena underscores as well, it describes, translates, and captures reality through words. As to its specific content, the book's chapters engage in the diverse experiments that have been undertaken in the region in the realms of constitutional transformation, property concentration, concerns about gender, and access to welfare policies. Finally, the last chapter deals with the book, what I take to be the book's main theoretical concern, the relationship between law and the transformations necessary to achieve social and economic development. I would like to focus on this very issue in the following minutes. Let me delve first very briefly and sketchily with the main theories about law and development. As Elena describes, there are two broad approaches to the relationship between law and development. The law at the service of other goals and the law-centered approach, which in turn has a liberal and a pro-market version. The first one assumes that law is very malleable and therefore especially suitable for implementing developmental goals. For such an instrumental approach, very similar to what Nonet and Selznick would call responsive law, law should be interpreted in the light of developmental goals. Consequently, this approach relies heavily on setting these goals, or the rules that encompass them, on the Constitution and implement them precisely mainly through administrative regulation thereafter. The law-centered approach, in turn, underscores the relevance of establishing precise legal institutions to achieve development, such as formal equality and separation of powers for the liberal version, or the strengthening of private law, property rights, and of the judiciary for the pro-market version. As opposed to the preceding approach, this one considers that only if these precise legal institutions are established, developmental goals can be achieved. Therefore, and turning back to Nonet and Selznick, rather than being responsive to changing social needs, some aspects of the legal system are autonomous in that they are insulated from politics and lay the foundations for either liberal democracy or a capitalist democracy. Yet, as the description of the constitutional amendments undertaken in Bolivia, Ecuador, and Venezuela underscore, the problem is that even if you establish the design necessary for having a legal system that can aptly adapt to accomplish developmental goals, these objectives might not be obtained. Similarly, as the Peruvian property formalization experiment, inspired on the prescriptions of Hernando de Soto, illustrates, establishing the right institutions also failed in achieving developmental goals. Accordingly, something more than just changing constitutional rules or legal institutions must be done to accomplish developmental goals, as if changing constitutional rules or legal institutions wasn't itself a daunting task, or perhaps following critical theory insights as to how law works. In order to address law and development correctly, we need to put into question our assumptions about what is law and how it relates to the economy. This leads us to the usual and unavoidable question: what is law? Following these insights, Elena conceives of law dynamically as an ongoing struggle over meaning. Accordingly, law is not a static set of rules that are clearly written and applied in a consistent and predictable way. It is rather a battlefield in which at every moment there are competing interpretations, promoted either by actors that try to promote their visions as to what it should be, administrative agencies full with bureaucrats exerting more or less discretionary power, and judges who will interpret law differently according to their theoretical backgrounds. Having said that about law, Elena turns to unpack what's law got to do with development. For these purposes, Elena underscores the need to unpack the range of interactions between law and development by unveiling the following assumptions and questions. First of all, assumptions about law and legal concepts in the dialogue between lawyers and economists. In this regard, Elena underscores that it is important to understand the basic assumptions that both of them have about law and the role these assumptions have in creating biases and distributing resources. This helps to unveil the fact that there is nothing natural or inevitable about economic development definitions and goals. They are only choices. Next, and closely related to the aforementioned, it is important to underscore that not all lawyers and economists share these assumptions. For instance, the ones concerning equality, liberty, the role of the state, or that of the market. Secondly, assumptions about the relationship between law and the economy. It is crucial to explore the various ways in which law structures the market. As Robert Hale demonstrated a century ago, the market is determined by legal entitlements that are outcome decisive and almost always remain in the background, which are termed background rules, such as the rules concerning property rights, especially the right to exclude, those criminal law rules that protect property, as well as those concerning vagrancy, labor laws, the ones that facilitate the drafting and enforcement of contracts, and those that frame family relationships. Next, questions of institutional choice. It is important to analyze the institutional choices that the three classical governmental branches or powers make to achieve developmental goals. For instance, whether one such policy is framed through command and control regulation or through the market. Lastly, questions about constraints. One must consider how these policies might interact with constitutional provisions. For instance, a health privatization policy with a constitutionally entrenched right to health. And lastly, one must not disregard the fact that local design of developmental policies through law are embedded in a global economic system, which might constrain as well policy choices. Concluding remarks. There is a limit to the law. This is a very useful book to understand the possibilities and limitations of law to accomplish economic and social developmental goals. I believe it is especially important to acknowledge the later, the limitations. Let me tell you why by providing a very contingent illustration. As you might know, and as mentioned in Elena's book, Chile is currently undergoing an unprecedented constitutional process aimed at the drafting of a new constitution by a democratically elected convention. It is expected that through the resulting text, Chile will be able to respond to those demands that propelled the 2019 social outbreak. If we lawyers humbly acknowledge law's limitations, we might accept that, though doubtlessly indispensable, a constitutional amendment that accomplishes to establish responsive, democratically elected branches might not be enough to respond to these demands. We might be some steps closer to better respond to these demands if we take seriously enough the interaction between the rules contained in the new constitution and those background rules background rules that Elena underscores. Similarly, and following the insights of the classic law and development scholarship, we need to consider the very environment we want to change by amending the legal system, including the habits and the ideas of those people that inhabit it. Before I finish, I leave Elena a few questions in case she wants to answer them. Background rules are blind spots, something we don't know. They generate interpretive cultures that later can perfectly permeate to the interpretation of rules that have a higher hierarchy, as is the case of constitutional rules. In Latin America, this has happened, for instance, with the civil rules concerning property, which are usually used to interpret the constitutional right to private property. Therefore, would you agree that perhaps the problem consists in accepting and following without critical examination the insights from classical legal theory, namely that the sole establishment of a rule of higher hierarchy will solve the problem? Closely linked to the precedent, one might think accordingly that background rules demonstrate how relevant is law for social transformation. Therefore, might it not be only a problem of focus? Put differently, could we affirm that law is very relevant for social transformation, but not for the reasons we usually give attention to? Lastly, where do you think that lawyers and legal scholars should place their energies? In devising the correct designs for institutions functional to development? In systematizing and illustrating the effects of background rules? In both? Once again, thanks to Jorge and the Rutgers University Law School Center for Transnational Law, and thank you, Elena, for your very well-written and thought-provoking book.
Thank you very much, Mattias, for those remarks.
So I'd like to just respond briefly, if I can, quickly, very quickly.
Go ahead. And then there are a few questions. People can use the Q&A function. And so we can ask Elena and perhaps Mattias if he also wants to address some of these issues. So Elena, would you like to respond immediately to some of the points that Mattias has put forward, or should I go ahead and read the questions?
Just very quickly, and then we can read the questions, just so I don't, because they're complex questions that were very well thought of. And first, I wanted to thank Mattias, which I should have thanked initially, but thank you very much. It's a very generous reading of me. Mattias and I've admired him for a long time. We're engaged in several projects, so thank you very much. I think I'm going to say something briefly about each point. The first one is, if I understood it correctly, so you identify very interestingly the problem of like traditional rules of interpretation, and that's why they don't have any effect. For example, if you have a very progressive constitution, but you still have private lawyers very immersed in civil law theory, then you're not going to have a change. And that is very common. I remember when I used to teach property that the property law professors would tell me, we never thought that the social function was something that we should incorporate into civil law. And so I do think that there's a work to be done, which is partly what I was referring to decentralize constitutional law, right? So for example, when Colombia did the transitional justice, the reparations, the land reparations, the land titling, that law was based on constitutional law. It had some parts that were progressive private law, but I think that we should concentrate much, much more, as Jorge Esquirol says, on progressive private law. And I think I think that you, Mattias, are one of the best persons to do that. Now, the second point, which is, I do think that law is relevant for social transformation. And I'm scared that the book is going to be read as too much of, it doesn't work here, it doesn't work there, it's not working anywhere. But I do think that there are many things that could be saved and are saved of the power of law, right? It's not, so think about granting rights to unions, or the process that is happening now in Chile, or the importance that the tutela has had in Colombia. Those are things that are real. But I say they're real, but we have to complement them with something else. And then finally, to the very interesting question about where should we concentrate our energy, which is a question I think about constantly. I think that actually we should concentrate our energy on both, as you suggested, meaning we shouldn't think, oh, because we're going to have, and I just finished writing something on gender equality, which is really, that's the point, right? So we have concentrated so much on gender equality as an equality clause, but actually there are a lot of things that are happening in the background, that there are a lot of background rules that are determining this. So thank you again, very generous reading, and thank you for the questions.
Thank you, Elena, again. I'm going to go straight to some of the questions that are here in the chat. One of the things that I wanted to mention actually has to do with something that Christopher Chapman raises here. He asked, I guess he said, is there an alternative to mainstream international finance with its focus on debt, neoliberal policies, and international interests necessary to break the cycle that has kept Latin America from providing for its people? And I think it's related to this question when he then follows up saying, what innovative ideas, similar to Ecuador's recognition of the rights of nature, may be beneficial to change the legal and social structures that are present in Latin American countries? I think the question is mainly directed to Elena, but Mattias, if you have comments on this, we would love to hear those as well. Elena.
But can you read the first question again, please?
Sure. Question says, is there an alternative to mainstream international finance with its focus on debt, neoliberal policies, and international interests necessary to break, I'm sorry, I misread this. Is an alternative to mainstream international finance with its focus on debt, neoliberal policy, and international interests necessary to break the cycle that has kept Latin America from providing for its people?
So I'll take that one, and then I'll answer the second one, because I think that, of course, I mean, I think that this is actually a wonderful moment to think about new ways, particularly of thinking about the economy. So if we think about is something that I want to study much more, I think it's called new monetary policy, this idea that you don't have to have a balanced budget, and the idea that austerity is not like the ultimate rule, the whole discussion that is happening in the United States now, which I find so interesting, about, oh, it's terrible that there's inflation, but that's purely an ideological debate, right? And so I think that one of the fascinating things that the pandemic opened the door to is there was like a common understanding that there were things that you could not do with the economy. Just to give you a very concrete example, in Colombia, a year before the pandemic, talking about universal basic income was like, that's impossible. Who's going to pay for that? Where is that? And now almost everybody is talking, I mean, on the left and on the right, and one could critique that. So my answer, without being an expert on, international finance, but I completely agree that this idea of the debt and, debt that is not even, the countries are never going to be able to pay for the debt, et cetera, et cetera. So rethinking, the economic structure, I think that is necessary. I think that there are tools out there. I think that there are people writing about this. And I think that for as horrible as the pandemic was, one of the silver linings is that it did open the door to, rethinking Keynesian economics, rebringing them in, etc. So that would be my answer to that. I don't know if Mattias would like to add something.
Yeah, I mean, like in the same vein that Elena replied, I think we should try some alternative. We need to try some alternative to break the cycle. I mean, one of the problems, and I think that's one of the biggest merits of Elena's book, is this kind of mentality of trying to applying one size fits all for prescriptions for different realities and contexts. So the things that you mentioned in your questions are these one size fits all solutions. So of course, I will be suspect to this kind of approaches. And I think Latin American countries should have room to look for alternative approaches to deal with the problems. I mean, there's something important about local knowledge. There's something important about decentralizations. There's something important about the people's view on the problems that directly affect them. So I would tend to agree that it's important to break the cycle and be open to this new kind of solutions.
Thank you, Mattias. The next question by Ana Segovia relates to the constituent process in Chile, in fact, and perhaps you may link this to something that is underlying in Elena's book. In fact, in terms of constitutional transformation, Elena's book opens with the constituent process and the social crisis in Chile. It's not 30 pesos, it's about 30 years. And personally, one question that I have is, there's always been this almost obsessive preoccupation with constitutional amendments and constitutional transformation in Latin America, as if that would bring about the changes that are needed. And Elena addresses this in her book, of course, but it'd be interesting to see this and to hear a little bit more in the few minutes that we have left. And I'm going to connect this to Ana Segovia's question, which is whether you can, what's your opinion on the current Chilean process and the fact that an indigenous Mapuche woman has been elected to lead the Constituent Assembly? How do you think, she asked, the US foreign policies will change as a result of the Chilean process, if you think there will be a change? Elena?
Thank you, but I think Mattias should also chip in because, so I feel very strongly, so actually I have been following a bit the Chilean process and it's admirable, right? So I think all of us, or at least I, wept when I heard many of the discourses in the assembly. It is, I mean, that weighs a lot. And I think that the fact that the Mapuche woman is going to be leading is going to make a huge difference, of course. I'm not, so I don't want anybody here to think that I'm saying that that's not important. But that is going to be, whatever constitution comes out, it's going to have enormous restrictions and not necessarily, so the US foreign policy, who knows, right? Because who knows who will be there, who knows how they will take it, who knows how they're going to interpret their interests. But still, Chile is part of a global market, you know, as Cuba, for example. I provide the example, which is really interesting about Cuba is really interesting because as much as they've tried to do many things and it's an authoritarian regime, I'm not defending them, whatever, but many of the things they really can't control them that much because they're part of a global system. Even in the embargo, they have to relate to, so part of one of the things that I was thinking about, and yesterday I heard a talk by David Kennedy was really interesting, is that one way to think about these issues is less in terms of a nation state and more in terms of the relationship of the nation state with its neighbors and with the globe. So Chile, for example, produces enormous amounts of copper. How is that going to determine whatever the Constitution says. I think that it is important, it's moving, it's going to be an example for the region. It's admirable, but it's going to be, there are going to be a lot of limitations. There are going to be limitations in terms of, you know, their position within the global market, but also the, you know, private law, the rules of corporations, the impositions of trade. I mean, a range of things. I went to Bolivia a few years ago and I presented a chapter that I wrote on neoliberalism in the Colombian and the Peruvian constitution. And there was a Bolivian judge who was the discussant for my chapter. And when I finished, he said, oh, you know, we didn't include anything neoliberal. And also we cut our ties, Evo cut his ties with the United States and blah, blah, blah. And I said, so who is buying your things? And he said, China. So I thought, well, there you go, right? They have to sell, I mean, because they're producing it. And so it's about the global situation as well. But Mattias, I don't know what else.
I tend to agree. I mean, yeah, it has been quite emotional, all the process, you know. I mean, I was kind of in a birthday party the other day with people I used to talk a lot during the nights of the social outbreak, and reminding all that energy and seeing where we are actually right now. I mean, and then seeing the installation of the convention, the discourses, the speech by the president has been really, really emotional. And as to what will happen to US foreign policies, I've learned through the years to be kind of very cautious when giving those answers. I mean, I can't give an answer for that because it will depend on various factors, which I'm not able to devise at this moment. But at any rate, I think it's true that, as Elena underscores, there will be limitations. There will be limitations or constraints from the global economy, and there will be internal constraints, background rules. But you know what? I mean, the whole thing is very valuable because at least we have the chance to establish rules, which later might translate to results or not. But the problem in Chile was precisely that for 40 years, we weren't able to establish a rule. So I take that to be a great step.
Thank you, Mattias. Thank you, Elena. We have time for, I think, the last question that I'm going to read out loud here from Marlene Lestage Laforce. She asked, Elena, you mentioned there's a correlation between the law and development in a country where the rule of law is not respected or is, quote, non-existent. How does the government apply or promote the rule of law? And let me just add one final question from Maite Gambardella. We have a few more minutes. She asked, how can we include the discussion about background rules, material conditions, and economic restrictions in the constitutional debate? Do you think that's important in order to open space for real changes?
Thank you for those excellent questions. So the first one is, I actually think that I would take issue with the idea that there's a country where there's no rule of law, absolutely. Actually, one of the interesting things in the book that I edited with Gunther Frankenberg on authoritarian constitutionalism is that authoritarians need some, there's some idea of rule of law. They just don't go out there and do whatever they want. And countries that have had dictators, I mean, there's some frame. Now it's a frame that maybe one wouldn't characterize as 100% rule of law, but I don't think that there is a country that is 100% rule of law, either the United States or anywhere. I mean, I think there's always some arbitrariness, authoritarianism, etc. So I think that I'm less thinking about those terms in an on and off, and I think it's more of yeah, it's a continuum. So there's a continuum between, there's no country that is purely obeys the rule of law and it applies everywhere. I mean, think about Black Lives Matter. And there isn't a country that is, you know, completely way out there, absolutely zero rules, or maybe there is, but I can't think of, I mean, I'm not in the countries that I'm thinking about. Now, Maite's question, which is very interesting, is should one include background rules into the Constitution? And my answer would be that's impossible, right? Because part of what I try to show in the book is that it's constantly moving. So the background rules are not a set picture. It's going to depend on changes in administrative law, which is Mattias's, for example, strength, or there are going to be changes in the international sphere and trade law, etc. So I think it's more of an issue in a programmatic sense. It's more of an issue of unveiling what you think is there, and less of, you know, trying to make a list. It's more of a methodological approach than a static one, would be my answer to that.
Mattias, would you like to add something to Elena's answer?
Yeah, I will. Yeah, I tend to agree with Elena's approach to the rule of law. I mean, in general, I don't think you can provide kind of an either all or an all or nothing approach. I mean, there's kind of parts of it, of one of the theories, some components of the rule of law might be there, some might not be there. And yeah, and there's also I think rule of law, it's kind of, even if you don't have a kind of rule of law that fills or complies with the World Bank standards for rule of law, or for the liberal standards for the rule of law, still governments will try to show their respecting the rule of law. They will try to kind of defend a very own way of dealing with the rule of law. I think there's kind of a symbolic thing into the rule of law that it's very idiosyncratic, and it's not captured in this kind of broad or all-encompassing theories. And as for Maite's very interesting question, yeah, I think this is kind of the when you say I want to find myself. It's a never-ending task. I mean, if you want to find the background rules, you will never accomplish that. I mean, it's very difficult to identify them. So what's the thing? I would try to deal with them kind of by a piecemeal approach, and while facing kind of the issues that engage those background rules, like when you have to give those interpretive battles or struggles where one of those background rules are concerned, I will place the energies there instead of trying to do something in the Constitution. I mean, there might be some more salient background rules, and you might target them in the Constitution, but you will never be able to target the broad landscape of background rules. But that being said, it is important to be aware of the existence of this broad landscape of background rules, so you can address them while you give the battle or the struggle in those specific issues that concern them.
Thank you very much. Thank you again to both Professor Elena Alvear and Professor Mattias Gilos for this fascinating conversation. I look forward to seeing how the discussion unfolds and how your book will impact ongoing conversations and of course future debates that are taking place, not only in Latin America, but also in other places around the world. So I also like to thank all the participants on behalf of the American Society of International Law Latin American Interest Group, and of course the Rutgers Center for Transnational Law. Stay tuned, more events and book talks are coming in the future, and stay safe. See you next time. Thank you very much for being here with us.
Thank you very much.